Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Jonathon Kappy.
And I'm Boris.
Welcome to Hull on Estates. You're listening to episode number 730. And today we are going to be discussing unique orders giving directions. So before that, how you doing, Boris?
I'm doing well. How are you?
Good. You may have noticed that normally when I do podcasts, I wear a shirt. Sometimes I wear a tie. If I'm feeling particularly bold, I wear a jacket. Today, I am not wearing any of those things. I am wearing a Blue Jays jersey because today, on the date of recording, it is October 24. And tonight is game one of the World Series, Blue Jays versus Dodgers. So we're all excited. I think everyone at the office has a Jays jersey. I know yours is sitting at the office. But I had to show support. So today I am going to do my podcast in a Blue Jays jersey. So go Jays. But let's get into this topic because I think that we've done, and our firm has done lots of podcasts on orders giving directions. But, some are more common than others. And some people may not think about when they think about orders giving direction. And so we want to use this opportunity in order to sort of canvas some of those weird ones.
Mm-hmm. So just to start off, in terms of my understanding of applications for directions, what I've been dealing with a lot is the classic will challenge where we're getting applications for directions for things at the beginning of the procedure, the proceedings, things like solicitor's files, medical records, and any other type of document that we need the court's help or the court's instructions to acquire in order for us to proceed formally. And that is usually our first step. But lately, I've been encountering situations where we need the court's help for things that are beyond those classic will challenges. And as I was reading it, I kind of learned more about applications for directions and creative uses for them. And to some degree, feels like it could be used as a almost catch-all to ask the court for help. So as I was doing more research and talking to other associates, I came across a few of the more creative uses of applications for directions that are specific to estates litigation. And that's kind of what we want to discuss and find creative uses in general for in this podcast.
Yeah, I think, listen, orders and applications for directions really don't have a limit in terms of there's no really definitional issue of where is an order giving direction. Mm-hmm. And if you look at Rule 75.06 of the Rules of Civil Procedure, sub 3 talks about what the court may direct on an application for direction. And it is fairly unlimited. If you look at it, it talks about, the court may give directions on the issues to be decided. Who are the parties? Who is the plaintiff? Who is the defendant? Who is submitting rights to the court? Who should be served? Procedures for bringing the matter before the court in a summary fashion. Whether there's an estate trustee that needs to be appointed and such other procedures as are just. So there really is no limit to what a court can do on an application for directions and in order giving directions. The court has wide discretion. Now, obviously, some of the things we're going to talk about, the jurisdiction for making such orders don't solely come out of the rules and the discretion that the judges have under the rules of civil procedure. They're governed by other statutes as well. Mm-hmm. But this is sort of the launching off point for those kind of orders.
And so the ones, sorry, go ahead.
No, please, go ahead.
The ones that I wanted to discuss with you on this podcast, they're the ones that are they're related to estates, they're a bit out there. So why don't we jump in with the first one? The first one that I thought was interesting in terms of estate litigation was the disposition of human remains. So things that are in a situation where an estate trustee might have to deal with funerals or burials or cremations, that sort of thing. And I've seen some applications for directions giving orders to that, but have you had any experience with that kind of issue?
Yes. Okay. And I think that we should, make a caveat at the top of this podcast to say that we're going to cover a number of really sort of cool, interesting, unique topics, but we are not going to talk about them exhaustively. Okay, so we're not going to talk about the underlying statutes or the core requirements you need in order to satisfy a court that you're entitled to the relief that you're requesting. Okay, but we're going to talk about them more generally to create awareness that these things are available without giving an exhaustive list as to what is required in order to be granted this relief. So I just sort of want to make that statement at the top of our discussion, because I don't want people to think that this is all you need to know in order to deal with burial of a body. Okay. But as we're talking about, so I have certainly had issues where there was disagreements among family members regarding burials. These things can come up in different circumstances. I mean, you could have, number one, a situation where a will isn't located or there is no will. And so there's no estate trustee. Now, we all know that an estate trustee is granted the authority to determine the burial of a deceased person. Sometimes the will contains sort of the requests of a testator, but they're not binding on an estate trustee. And so sometimes you have circumstances where there is no will. Sometimes you have circumstances where there is a will, but it's not being located fast enough in order for a funeral. And sometimes you have circumstances where there is a will, there is an estate trustee, they want to either bury or cremate or deal with the deceased remains in one way, and other members of the family don't agree. And you can have fights over, should they be buried? Should they be cremated? Should they be buried in this particular place or that particular place? Should the ashes be scattered in this particular country or off the coast of this particular ocean? And this can come up. And so this is something that a court can deal with, okay, as part of direction. Now, the limits on, I guess the core principle for this one is that the estate trustee must deal with remains of a deceased person in a dignified fashion. That is sort of the core principle which governs the authority of the estate trustee. Okay. Now, that doesn't necessarily mean that the estate trustee has to adopt one religious belief over another, bury them in one particular place or another. And so disputes can arise in these kind of things. And oftentimes, or I wouldn't say oftentimes, I'd say sometimes, the parties need the court to help resolve that issue. And I think that probably more times than not, the court is going to side with the estate trustee so long as the deceased person's remains are being disposed of in a respectful and dignified manner. I mean, that is sort of the core principle behind all of this. And so, this is one of those situations where you're going to go before the court and one person is going to have one view and another person is going to have another view. And oftentimes nobody is wrong, they just have different views. And it'll be for the court to either decide or defer, right? They may just say, it's not for me to say, the estate trustee's decision, they have the authority and it is a respectful and dignified manner, and we'll go with what the estate trustee says, or obviously the court can say they don't agree.
And that's a very important part of the process. As you're administering a estate, you want to put the person to rest. Like you said, the court's prerogative is to first make sure that they have a dignified place. And but sorry,
please go ahead.
In the kind of like the offshoot of that, once a person has been put into the ground and given a proper burial, I've also heard of situations where people have been exhumed after their burial and returned to the land of the living, so to speak. But in order to and that was, as a result of an order giving directions. And so I thought that was interesting because a colleague at her firm had a situation where that had happened. And and it was interesting to see that the court was willing to make an order, and in light of the situation surrounding the estate administration. But have you also had to deal with that?
I've had to deal with that for sure. I'm not going to get, I don't want to get too deep into what is required in order to convince a judge that a body should be exhumed, but there are a number of reasons to do it. Sometimes it has to do with, burial location. This is sort of the topic we just finished with. Sometimes, someone goes ahead and buries them in a certain place, and the family wants to move them to another place, and you get a fight over where they should be buried. Other times, you get into situations where the body is required to resolve a particular legal dispute. And so sometimes you're going to have to ask the court to exhume a body. So, and this sort of goes on to a third topic that we want to talk about, which is DNA testing. Okay, so there are situations that arise where the person dies, let's say intestate, but that doesn't have to be the only case. And a particular person comes forward and says, I am a child of that deceased person. And, if they were never had a relationship with the deceased, or if there's doubt as to the actual parentage of the deceased, then a DNA test is going to be the only way to resolve it. But if the person's already been buried, then the only real way to run the DNA test is to exhume them. And so I actually have dealt with that before. Even where, and I can tell you that even where all of the parties agree that they want to exhume a person, the hardest person to convince is the court. Okay, because the court has such respect for these deceased, either testators or intestate deceased people, that they don't want people just digging up bodies, to be fair. Right. And so they are the hardest critic of trying to exhume somebody. And there's legislation that's involved. There's a lot of, there is some case law. There isn't a lot of case law on exhuming bodies. But it can be done. And if there's good reason. Obviously, the court's not going to do it just, for silly reasons. But if there's a legitimate reason, then the court will do it. And so, that's sort of the first part of, exhuming a body. And then the other part that, in an or given direction that it can relate to is DNA testing. So where you have this situation that I'm talking about, where the parentage of a potential beneficiary is in dispute, then you're also going to have to deal with a protocol for DNA testing. Obviously, you're going to need to get a DNA sample from the deceased person. You're going to need to get a DNA sample from the potential beneficiary. And, an order giving direction can help set out a protocol to make sure that it is done properly, it is done by board, it is done by professionals. And so that once the results come back, everyone is satisfied with the results. Whether you're happy about the results or not, at least you're satisfied that the process was done properly.
It was done fairly. It was almost court supervised, and it was given the fair chance that everyone gets a say. And so that's really interesting. And I definitely brought this up to a few friends who are not in the States, and I was mentioning them. I was doing a bit of research into DNA, and they were all, I guess, dumbfounded. Like, why would you need that? Why would you? Isn't that a criminal procedure? Like, yada yada yada. And it was also kind of interesting to talk about, exhuming bodies. Like, this is really like you are diving into someone's life, and like you're taking on very personal issues and asking the court for that guidance. And I think in some situations, like for example, my friends in corporate, they don't really deal with that. So it's interesting to see the guidance of the court come into play for issues like that.
Yeah, I mean, listen, anytime you're talking about sort of the final resting place of a deceased person, you have to treat them with respect. All right. So, and the court is going to treat them with respect. And the parties should approach this solution with respect, always having respect for this deceased person who has passed away. They're buried, or they should be buried in a timely fashion. Like, I've had cases, and it's like the worst case scenario where the family couldn't agree on where to bury a person or who should be in charge of the funeral, and this person sat in a funeral home for months because they couldn't agree on a funeral, or where to bury them, or who should be invited, or things like that. And that's just stuff you got to try to avoid. I mean, and I think a court will try to deal with that as quickly as it can in order to avoid those kind of things. And this goes hand in hand with another one that we talked about off camera, which is safety deposit boxes.
That's right. Yeah.
So Obviously, it's best practice for a person who makes a will to tell their estate trustee, I've done a will, you're the estate trustee, this is where you can find my will. Doesn't always happen. And so it may be hard for an estate trustee or any family member looking for a will to find one. And so oftentimes access to safety deposit boxes is one of the ways that people can do that. And the court can, on an order giving directions, create a limited right in order to look at safety deposit boxes. Now, the reality is that sometimes that's not necessary. Okay, so there are banks that have protocols for people looking for wills when a bank client has passed away. And the best protocol that I've seen, and I don't want to name the bank, but when someone is looking for a will and they go to the bank and they say, I understand that this person had a safety deposit box, I'm looking for a will, I want to access it. What they will do is they will go into the safety deposit box room with this person who's looking for it. They will have two representatives of the bank. Okay. The bank will open the safety deposit box. That requesting person is allowed to be in the room, but not to look into the safety deposit box. Okay. The two members, representatives of the bank, will look in the safety deposit box, just them seeing, nobody else, and they will determine whether there is a will in the box. If there's a will in a box and the person who's requesting it is the named estate trustee, they will release it. If the person is not an estate trustee, they will identify that there is a will. Sometimes they will or will not identify who the right person is that can request it. But no one else, that during that process, nobody else gets to look in the box and figure out, is there jewelry, are there bonds, are there coins, whatever it is.
Right.
You're looking for a will, that is the limit that they will allow you to know what is in that box until they confirm that you are the estate trustee, which is kind of cool. I think that's a good way of doing it. It's practical. It helps the administration of the estate, especially if they're holding on to a will. Unknowingly, the bank doesn't know what's in the box. But if they do have a will and the person is the estate trustee, it makes sense for them to allow them access without going to court for that.
Of course. Yeah.
But if you have somebody or a bank that's has different rules, an application for directions can be used to gain access to a box on a limited basis to determine when you're looking for a testamentary document.
Yeah, and then another very useful strategy or tactic to have in your tool belt, in case you run into that issue. And I have heard from a colleague, he had an issue before where there was only rumors of a safety deposit box. It was never written down anywhere. It wasn't in the will. And it was an issue with multiple wills. So an application for directions was the strategy that was implemented in order to make sure that the parties had the last will. And that was it.
Nowadays, with technology and all those kind of things, will banks are such a great idea. Where people can, there's an online bank of wills, and you can sort of input your information. Say, this is my name, I've got a will, this is the date, and this is who has it. And people can look up and find, where this will is, and then they know to ask, where to look. Because if you don't tell your estate trustee, I'm making a will and this is where it is, there's so much going on when somebody passes away, especially if it's your family members, your kids, your spouse, your parents, in terms of dealing with the emotional element of this loss, dealing with funerals and things like that. That having to hunt for a will is sort of the last thing you want to do.
Yeah.
So people can really do their family a service by letting them know where to find this will.
Exactly, yeah.
So I think we're getting close to the end of our discussion. I think sort of the point of all this is that applications for directions and order giving directions are really powerful. And there's no set rules as to what can or cannot be done in an order giving direction. And I think it's, proportionality is sort of a big factor. It's something we also talked about off camera. Don't overreach, but if there is something that you need, that the parties need in order to move forward with the process, whether it be the administration of the state or move forward with the litigation, there are remedies available. There's no set rules as to what can be done in an application for directions. But it's going to have to be reasonable. It's going to have to be proportionate. and it's going to have to be respectful of a deceased person, their remains, their privacy, and those kind of factors.
Mm-hmm.
So I think that brings us to the end of our discussion. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
And I'm Boris.
Did you have any questions? Please email us at info@hullandhull.com or contact us through the contact page of our website. Have a great day and go Jays go.
Go Jays go.
Thanks.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.